Good afternoon, everyone. Thank you so much for joining us today for Deferred Action for Immigrant Workers Involved in Labor Violations. For those who don't know me, my name is Alexis Alvarez, and I'm the Director of Statewide Training at Florida Legal Services. I'm very excited to be here today in community with you all to learn, and very excited to be with our speakers that we have here. As always, I'm going to start with some quick housekeeping announcements. First and foremost, this is being recorded. A copy of the recording will be sent out to everyone who registered. If we go over time and you have to hop off, don't worry, you'll still get a copy of the full recording. Second piece of housekeeping announcements, questions and answers. We always want to hear from you, and we always want to hear your thoughts and your questions. If you can, please post your questions into the Q&A. Try not to put them in the chat. We're looking at them in the Q&A, and we will do our best to answer them as they come up if we have the time, or certainly at the end if time permits as well. So don't be shy, put them in. Third piece of housekeeping announcements is CLE credit. This webinar has been approved for CLE credit, and that CLE code will be announced at the end after we've gone through all of the substance, and it will also be included in with the copy of the recording that you all will receive from Zoom within 24 hours of this event. I think that's my main housekeeping announcement list. I always get to do the boring stuff. I always have my speakers that get to do the cool stuff and talk about that. The last thing I will say is I want to give a shout out to our co-sponsors. We have a few co-sponsors on this awesome webinar today, one of which is the Public Interest Law section of the Florida Bar. As always, I'm always giving a shout out for them, a great organization and community of lawyers doing good work and collaborating with each other to support each other. So join PILS, be involved, and thank you all for everything that you do and for being here. And with that being said, I'm going to turn it over to Victoria to take over for introductions and any other housekeeping matters that I may have missed. Victoria?
All right, well, good afternoon, everyone. Thank you so much for joining us. I'll try to keep my remarks short as we have a lot of content that we're going to be sharing with you. But as Alexis said, I'm Victoria Mesa-Estrada. I'm a private attorney now, a former legal aid attorney representing farm workers for over 13 years. I have changed practices since then, but this work is still very dear to my heart. And when we decided to do this presentation, I really did it thinking of the need that we have in this state, given the number of immigrant workers that are laboring, whether it's in the fields, cleaning offices, we all know those positions that they all take. But unfortunately, there is a huge need for legal representation to help them as they navigate, their rights. So this presentation is really targeted to that, to something that is very new that we hope that you take and consider doing those cases. You are going to be talking to the experts today, the people who have been on the trenches developing this new temporary immigration relief. But before I go into the introductions of our panelists today, I also wanted to thank my other co-sponsors. So I am the president of the Florida Hispanic Bar Association. We are an organization that was created right before the pandemic. So we kind of went on pause, but we're trying to reorganize and bring together all the Hispanic attorneys and legal professionals that are in the state of Florida. So please hit me up if you're interested in joining our organization, becoming part of our board. It's a very exciting time for the Hispanic legal professionals in our state. And secondly, I do want to say thank you to our co-sponsors, Horizon Legal Solutions, Milestone Reporting, and my firm, Denney, Scarola, Barnhart, and Shipley, who are co-sponsoring this event, so we can provide this content to you for free and not charge for the CLE events. So with that, let me briefly introduce our speakers. So first, I'm going to start with Shelly and Anand. And Shelly is just fantastic. Her bio is very impressive, but I would like to introduce Shelly for the person that I met. I met Shelly on the trenches at the beginning of January 2021. So it had been 7 months during the pandemic. And this horrible tragedy happened in Gainesville, Georgia, that killed, I believe, about 7 individuals at this poultry plant. And Shelly had just started this nonprofit to assist essential workers during the pandemic on all sorts of legal issues. And Shelly and I connected to try to provide triage to those impacted individuals workers in the poultry industry who do this day and night and who were not getting any help from no one. The state was not there, local authorities were not there, no nonprofits were there, and even law firms were not there. But there was a huge need to help these essential workers. And through that relationship and seeing the work that Shelly was doing, we worked together with many other allies in advocating for a change within the federal agencies to assist workers, immigrant workers who were collaborating in the investigation of labor violations. So Shelly will talk more about how that policy came to happen, but I really wanted to give that huge credit to her because she brings an incredible expertise in OSHA, in labor law in general. She's been doing this for a long time. Her experience working for both the federal government and the nonprofit sector has been huge, and she's really a nationwide star. I mean, she's really done incredible work. And then as her organization grew, she's been able to hire other superstars, like her second panelist, Elizabeth Zambrana, who is their legal director. And Elizabeth as well, she's the daughter of immigrants. She's very passionate and a dedicated advocate for immigrant rights. She'll talk a little bit about her background in immigration law, but she's on the trenches working with communities, helping support organizations that are doing the work in support of the immigrant communities. And then she's growing this amazing project at Sur Legal that I do hope that you all consider reaching out to, connected with them, because I think there's really a great potential for the state of Florida to start doing more work of this kind. So with that, I'm gonna pass it to our speakers. I will be sharing my screen for the presentation. Ladies, please let me know as you need me to change the slides. I will do so. And for now, I'm just gonna mute myself and I'll be checking the chat or the questions and answers and making sure that we address all those questions, okay? So thank you so much. Thank you everyone, welcome. And I hope you enjoyed this presentation.
Yeah, Victoria, thank you so much for those intros. We can go ahead and hop on to the next slide. So we do have quite a bit of material that we would like to cover for y'all today, but just, a brief overview. We want y'all to have an understanding of what a labor complaint-based deferred action is, some basic screening tools and questions that you might be able to ask folks that you come in contact with as to whether they've been a victim of labor abuse, where they can file their labor complaint if they haven't already done so by the time that they come in contact with you, how you can go about requesting a statement of interest or showing them how to request a statement of interest from the labor agency, as well as screening for negative immigration or criminal history and positive equities that you may want to include in your application, the actual nuts and bolts of a deferred action application, as well as some challenges we've encountered as we've been doing this work and some best practice tips. At the end, we will be sharing some helpful resources for y'all, including our contact information. So again, just thank you so much for putting this together, allowing us to share this information with y'all. We're very excited. Next slide, please. So just a brief overview of SOAR's focus and the work that we do. I know Victoria talked about it, but just, the specific services that we provide. We work at the intersection of both immigration and labor law, and specifically in terms of the legal representation that we provide, we will provide legal representation and technical assistance to individuals who need to file labor complaints before OSHA, wage and hour, NLRB, and we will also provide legal representation and technical assistance on any forms of immigration relief that these workers may be eligible for as a result of an underlying labor abuse complaint. So this includes deferred action, but it also encompasses U visa and T visa representation. Another big component of the work that we do is our popular education and know your rights presentations. We're really big believers in democratizing legal knowledge and really putting that knowledge directly in the hands of workers themselves. So I really strongly recommend, if you haven't already done so, to take a look at our Instagram. We have some really helpful resources, including infographics and explanatory videos, and they're both in English and Spanish, and you can feel free to use those tools as you need them, or you can also share them directly with your clients. So I know that this group is mixed, in terms of immigration providers, as well as seasoned labor experts and other areas of expertise. So this presentation will be geared toward both audiences, but if you have any points of clarification, please feel free to pop any questions in the Q&A box as you need to. Next slide, please.
Sorry, I'm having trouble moving them.
No worries.
My apologies. Let me just see what's going on here.
And if you need me to take the remote control, I can probably do that.
There, oh, sorry.
Perfect.
Okay, great. Well, thank you, Victoria, and everyone that invited us to present today and to share this information, this new tool that's available in the toolkit in supporting vulnerable immigrant workers and vulnerable clients that we all interact with. So I'm just going to go a little bit over the history of how this new process came into being. As Victoria mentioned, about 3 months into our founding of Sur Legal, there was this horrific tragedy up in Gainesville, Georgia, where 6 workers died and had a worker population of about 130 workers that were there to witness this horrific nitrogen leak that took place. And Gainesville, Georgia is known as the poultry capital of the world. It's also a very anti-immigrant county. It has a 287G agreement where local law enforcement can enforce immigration law. So it really is a workforce that is silenced and chilled from speaking up against workplace abuses in one of the most hazardous industries in the world. And so in the aftermath of this leak, Victoria and myself and a bunch of grassroots organizers and other nonprofit legal organizations were advocating for some form of protection from one of the worst forms of retaliation possible, which is a call to local law enforcement or a call to ICE to put a whistleblower, to put a witness into deportation proceeding. And so this policy is kind of the outcome of years of advocacy, even dating to before the nitrogen leak in 2021. But I think these deaths were definitely a catalyst that moved our government agencies to put some policies into practice. So in terms of deferred action, generally, that has long existed as a form of prosecutorial discretion. Being able to grant deferred action is not new. But in January of this year, DHS did publish guidance on a streamlined process that was specific to immigrant workers that are involved in labor investigations on the local, state, or federal level, being able to apply for and be given a form of temporary protection from immigration enforcement as well as a work permit. In the aftermath of the leak and the kind of call to action, DHS did start by issuing a worksite enforcement memo, pushing for the kind of a mutual facilitation between DHS and federal labor agencies like the Department of Labor, as well as the National Labor Relations Board and the EEOC. And Elizabeth's going to get into what those agencies are for folks that are not familiar. And really trying to find a way to protect workers from fear of immigration-related enforcement so they felt safe and comfortable coming forward to the federal agencies and sharing the labor abuses they had endured or witnessed. So this new streamlined process, allows for workers to submit an application for DA as well as a work permit simultaneously to a centralized processing center in Montclair, California. So we'll be talking about what that application looks like. Workers who receive deferred action and work authorization, it's available for a period of 2 years with the possibility of renewal. That is an area that needs to be developed and a potential challenge that we're facing right now. So that is also something that we'll talk about. There are other forms of relief available. Deferred action is a form of prosecutorial discretion, but there's also parole. There's also actually, requesting prosecutorial discretion from OPLA, depending on which is the attorneys for ICE, essentially. And we're really going to be focusing on deferred action, those applications that are going to be going to Montclair, but there are other forms of immigration relief outside of strictly DA that we won't be touching on today, but again, happy to talk to you offline and provide technical assistance or get you in touch with folks with expertise in those areas. Next slide, please. Oops, I think one back. Okay, so this is kind of a general overview of what are the steps, a worker, an immigrant comes into your office. Well, how do you ascertain whether this is, something that they would qualify for? And so the steps are, screening your worker, screening your client to ascertain whether they're a victim of a labor violation. And Elizabeth's going to give you an overview of how to ascertain that if you're not familiar with labor laws. For the purposes of today's presentation, we're going to be focusing on federal labor laws. Obviously, we're in the South, and so I think we do have state and local labor agencies, but they're not really kind of looped in yet on this process. So right now, the focus, especially in Georgia and in a state like Florida, is getting these statements of interest or support from federal agencies. And so you're going to screen, your individual client or worker for whether they're a victim of labor abuse or have witnessed labor abuse. And then you're going to figure out, okay, has a complaint already been filed, or do you need to file a complaint? And then simultaneous to that, requesting what's called a statement of interest or a letter of support from that labor agency, figuring out if there's an existing letter that exists that's already out there, if there's a pending wage hour or EEOC investigation, or if you're going to need to make that request yourself. Simultaneous to that, you're going to be doing an immigration screen. You're going to be screening your individual client or the worker about their immigration history, kind of ascertaining, when they came to this country, the number of times they've entered and exited, if they have ever been in removal proceedings, if they have orders of deportation and orders of absentia in their record, and determining whether you need to do a Freedom of Information Act request. And so those kind of three things are kind of happening simultaneously. And then once you have your statement of interest, and once you have a clear understanding of your client's immigration history, you're going to go ahead and prepare and submit the DA application. So we're going to be going over these steps with you today, so you can just get a general idea of what the work entails to see if your clients are eligible and should apply for deferred action. Next slide.
So as I mentioned earlier, we are going to be sharing some detailed tools and resources with you all, including detailed screening tools, but just a very, very basic overview, especially for folks like myself who are not labor experts, just some really basic screening questions and things to look out for that you can keep in mind as you connect with these individuals. So if someone is owed wages or they are owed overtime, they may have been, they may have experienced a labor abuse violation in that context. If they have any kind of safety or health concerns about their workplace, or if they have actually gotten hurt at the workplace or witnessed someone else getting hurt, if there's any fear of folks getting hurt or exposed to perhaps chemicals in the workplace, that's something else to keep in mind. If they have experienced or witnessed some kind of discrimination or harassment, especially if it's based on something like sex, race, or national origin, something to keep in mind and something to ask folks. And if they or their coworkers have ever been threatened or retaliated against for organizing or speaking to one another to try to improve working conditions, and this could be, ranging from asking for better pay or better hours or safety conditions, if they have been retaliated against for this. This is also a potential labor abuse violation. The one caveat that I will flag is that some of these folks may be independent contractors. And so if someone is an independent contractor, they may not actually fall under the purview of Department of Labor or NLRB or EEOC. We will have some resources to share with y'all at the end on this topic, specifically related to misclassification. Some employers will misclassify individuals as independent contractors when they are, in fact, employees of the company. And so we do have some tools to help y'all ascertain whether that may be the case in your particular circumstance. Next slide, please. So what happens once you determine that somebody has in fact suffered a labor violation and you know that they're not an independent contractor, so you know they are covered under federal labor law, but this person has not yet filed an actual labor complaint. So you as the advocate or even a non-lawyer can, such as an experienced labor organizer, can actually help these folks file their complaint. So if you are going to assist somebody in filing their labor complaint, what we recommend is that you actually have them sign a release that designates you as the employee representative before that agency. And so we have this really helpful table chart, which continues actually onto the next slide as well, but it lists out all of the various agencies that handle these labor complaints, as well as the laws that they enforce and the rights that they protect, and the relevant statute of limitations that exist for filing those complaints with that particular agency. So again, this table will provide you just a basic overview of the different potential agencies that may be able to receive this complaint from your client. Next slide, please. So using this chart, as well as the screening tools that we'll be sharing with you at the end of this presentation, you can kind of, gather which agency will be the most appropriate. So if you're dealing with an issue of unpaid wages, the most likely agency that you'll be dealing with is the Wage and Hour Division. If you're dealing with an issue of race-based discrimination, the most relevant agency is going to be the EEOC. And so just, doing a basic screening, taking a look at this, you'll be able to have a good sense of where to file. And in the event that you don't feel comfortable assisting the individual, they can always file it pro se, and you can simply point them in the right direction. We also have links under each of the titles of the agencies to their actual complaint page, so they can file those complaints online, or if you want to assist the individual, you can do it for them. Something that I did want to flag is that there are certain agencies, the EEOC and the NLRB specifically, that have stated that they are willing to issue a statement of interest even before the actual labor complaint is filed. And part of the reason for this is because those agencies specifically don't provide for a process for individuals to file anonymous complaints. And so this can be very daunting, very scary for folks because they are essentially outing themselves, and that information will ultimately get shared with their employer. And so these agencies have affirmatively said, if there's an extreme fear of folks getting retaliated against by their employer, they are willing to consider issuing the statement of interest so that these folks can access the protection of deferred action and then go ahead and file their labor complaint in that situation. Next slide, please.
So I'm going to talk a little bit about, requesting a statement of interest from a labor agency. So as mentioned previously, these statements can be requested from any federal, state, or local labor agency. A statement of interest is required for any application for labor-based deferred action. I'm going to say that again, it is required. These applications without a statement of interest will be rejected as incomplete. And unfortunately, some of the first applications that ended up going to Montclair with the January 2023 announcement, a good number of them were rejected because they were sent in without a statement of interest from a labor agency. So that is it's like a U visa certification. You have to have it in order to be considered for this form of relief. The statements, once issued, will be sent directly to DHS and to the requester, and DHS will be comparing the two. So when your application goes in, you should just be prepared for them to be pulling up the statement of interest that was issued regarding, that specific investigation, and the two will be compared. Only one statement of interest is required per investigation. So you don't need each individual worker requesting a statement of interest on their behalf. We are really encouraging these letters requesting statements of interest to be as expansive as possible. So even if you have one individual worker that's come to you, I'll give you an example. We have a worker in Texas who is a Mandarin speaking worker who was working at an acupressure salon, and he was the only whistleblower that felt brave enough to come forward and file relevant wage and hour and OSHA complaints. And we're requesting a statement of interest on his behalf, but we're making sure that statement of interest is not just going to be for him, but it's for all workers, former and current, that experience the same labor violations that he did and or were witness to them. And so this way, there's one letter that can cover a whole cohort of workers, and it's not duplicating efforts in terms of trying to get this necessary document for what could be a very large workforce. I mean, the letters that we've gotten for this population in Gainesville, like I said, it's 130 workers that witnessed and experienced the underlying OSHA violations that led to citations. I'm sure you've seen the news about these horrific child labor law violations that are happening across the country. These are workforces going back to 2019, covering a large array of facilities across the country. And so it's a tool that makes it available for this form of relief available to a whole cohort of workers. In your request for deferred action, you don't necessarily need to even include the name of your client. You can, but you're not going to want to put any other information in the letter regarding their immigration status, or anything that you wouldn't want to get into the wrong hands. So you're not going to be putting A numbers. You're not going to be putting sensitive information about the workers in this request for a statement of interest. Next slide, please. So what should you include in your statement of interest? You're going to want to put information that identifies the workplace, the name of the employer, the location, and then details of the underlying labor violation to show that they're in violation of a law that the relevant labor agency enforces. So you can talk about, this worker got a chemical burn, on this date, and these are the issues that came up, and they want to file an OSHA complaint. You might also want to talk about any threats or retaliation witnessed or feared, even if it didn't occur, related to the underlying labor violation. If there's a history of supervisors or HR staff bringing things up around their immigration status, or making threats to workers. We have a client right now who worked for a restaurant for a number of years and as a cook, and was often threatened and harassed. Whenever he brought up a concern about an issue in the workplace, his employer would remind him, like, you're undocumented, I could call ICE on you, I could get you deported, basically trying to silence them. So those are the details you want to include. And just a description of how fears of immigration consequences are chilling for workers wanting to report labor violations or wanting to cooperate in an investigation, and the potential impact on the investigation and enforcement of applicable labor law. So, these workers are willing and able to come forward if they have this protection. You might also want to include other details. I mean, in the Gainesville case, we definitely brought up the fact that this is a 287G county, and kind of some legal structures that are in place that prevent workers from coming forward. I know Elizabeth said that, the NLRB and the EEOC have explicitly, said that they will accept requests for statements of interest even before a charge is filed. I would say that, even though the informer's privilege or the right to anonymity exists in the OSHA wage hour context, I think as advocates and as zealous representatives of our clients, if there is still this fear of even filing an anonymous complaint, it's a small workforce, or the underlying violation will make it very obvious who's filing the complaint. I mean, I do think as advocates, we should be pushing the agencies within DOL to also issue statements of interest before an underlying labor complaint is filed, if that's what a worker wants.
Shelly, we have a question in the chat.
Sure.
Specifically regarding the statement of interest.
Mm-hmm.
USCIS make it an issue that the name of the person requesting the aid is not in the statement of interest?
No, so I mean, we're going to be getting to that later, but within your application, you basically are going to have to provide evidence to show that your client is covered by the statement of interest. And so, for example, in Gainesville, what we did was we got an email confirmation from OSHA that this worker participated in an interview regarding this underlying violation. And so that was enough to get them, through the door and get them deferred action. So you're going to be providing in your application for deferred action, you're going to have this statement of interest that's going to cover a large swath of workers and not individually name the workers, but then there's other evidence you can put into your application to show that your client is covered by the statement of interest. And we'll be getting into that in a little bit.
So at this point, potentially and definitely prior to actually filing the deferred action application, the worker should definitely have a detailed immigration screening and criminal history screening done, whether that's by you or an experienced immigration practitioner can also do that screening. This is really, really, really important so that the worker can actually assess the risks of applying, and those risks are very particular to their individual circumstances. So it's just really important to have this information and for them to be able to make the informed decision as to whether or not they wish to proceed. The other reason that this is really important is because it's actually going to inform how you proceed in the deferred action application. If there are any potential negative immigration history or negative criminal history, you're going to want to offset those with positive equities that you're going to be including in your application. And so for those of you who are not immigration providers, some examples of adverse immigration history can be prior removal orders, prior, contact with immigration and enforcement. This information is ultimately going to be having to be disclosed on the deferred action application, as well as any adverse criminal history. So just, a practice pointer from us and based on our experience, as overly cautious, providers, and we really want our clients to make informed decisions about their case. If there's any doubt whatsoever as to their immigration history or their criminal history, we really, really strongly suggest that y'all do FOIAs or background checks for your clients. The downside of doing this is that it really delays the amount of time that it takes to get these applications filed. And the reason for this is because there is just a really huge backlog at these agencies in terms of, adjudicating these FOIA requests and actually getting those records or information back to you. So that's kind of a downside and something that you should present to your client, and they'll have to weigh in their individual circumstances, what the cost benefit analysis is in their specific situation. Our recommendation is, if your client really wants to proceed without doing these FOIAs or background checks, is to have them actually signed an informed consent agreement, just making sure that they really understand that there are risks of proceeding without having a complete picture of their immigration history or their criminal history. So that's just a practice pointer that we wanted to share with y'all. Next slide, please.
Okay, so once you've kind of gotten your statement of interest, you've done your FOIAs, your FBI background check, your open records request, and you have a good understanding of your client's immigration history. This is an overview of what's going to go into your deferred action application. So prior to the January 2023 streamlined process that DHS announced, we were basically applying for deferred action first, and that was with the local field office. So, depending on where the worker was living, the DA application would go to the local field office. And then once that DA application got approved and you got a letter granting deferred action, you would apply for an EAD. Now the new streamlined process is that you're completing an application both for DA and an EAD simultaneously. If that does require your client will either have to pay the $410 filing fee or complete a fee waiver. If your client does not want to do the EAD application simultaneously, then their individual DA application will have to go to the local field office. We don't really have a sense of how long it would take if you were to apply for DA with the local field office. I mean, they're kind of under instruction in Montclair at the centralized center to expedite these requests, move them quickly. And I think that same message isn't, happening in the field offices because they're getting everything. So we are encouraging folks to go through this process, but they might be out $410 if their DA application is denied. And so that is something to make them aware of. So if they're represented, oh yes, thank you, Victoria, EAD, Employment Authorization Document. I'll also say that Elizabeth and I have kind of switched places in this presentation. I'm the labor person and she's the immigration person, but we're kind of cross-pollinating here in our areas of expertise. But I will say, as a labor attorney, I have done these applications, so you can do it if it's not overly complicated. So if they're represented, you're going to do a G28, which is essentially like a notice of appearance for immigration practitioners. You're going to also complete a form that's called a G325A, and this is a form that is for deferred action specifically. It's going to have you're going to be getting information like their past 5 years of employment, their past 5 years of addresses, their addresses in the home country, their parents' information, date of birth. It's a lot of information. Another pretty critical component to this form and to the application generally is, workers having to share if they've used other names. This is a pretty big issue with immigrant worker populations who are, either, forced to or end up getting false name, false ID. You're not necessarily admitting explicitly, I got a false social security number or a fake name, but you are having to share other names used in this document. And that is something you need to advise, your clients about, that they can't. We had a client that was like, I don't want to do that. And we just had to explain, like, omitting this information could have long-term implications for you. If you don't come forward about this now and down the line, you're eligible for a U visa, you're eligible to adjust, and you haven't, you're going to get a waiver, for instance, about this, this use of false names, but they see that you weren't forthcoming in your DA application, it could make you ineligible for other forms of relief. So really taking the long view in these applications. It is temporary, it's only 2 years. So being as forthcoming as possible so that future applications are not jeopardized. You're going to include a signed statement requesting DA from the client. And in this signed statement, it doesn't have to be long. Previously, we were having to do affidavits and all that. It doesn't have to be long, but it also depends on your client's immigration and criminal history, or quote unquote negative equities. If they've had multiple entries, if they've had orders of removal, things like that, you're going to want to put that in their signed statement, and then also put in positive equities. Like, I have US citizen children, I've been a part of this community for 20 years, I do bake sales at my church, all of the kind of kitchen sink positive equities. You're going to want to go ahead and do that in the statement, making it more like a affidavit or declaration, depending on their history. You're going to include your SOI, proof that the worker is within the scope of the SOI, proof of identity and nationality, so birth certificate, passports, birth certificates of US citizen kiddos, things of that nature. And then you're going to do your I-765 employment authorization application, as well as the worksheet where you kind of go over their income and expenses and show that they need to work. And we usually include information like, I'm the sole breadwinner. The population in Gainesville, a lot of them are single moms to US citizen children, and are the sole breadwinners. And so, they have a whole community and family that's depending on their income. You're going to either provide the filing fee or do a fee waiver and provide evidence for that. And that could include evidence of, receiving public benefits, kiddos are receiving public benefits, things of that nature. Again, depending on, the history or the background of your client, if there is, order of removal, or they're in pending immigration proceedings, or they have, had a number of traffic stops, or, some sort of criminal history, you're going to want to include evidence of positive equities, letters of support from US citizen community members, lawful permanent resident community members. We used, a US citizen child writing a letter about how mom has always been there for him and made sure he went to school, and, just trying to better his life, and give him the life that she didn't get, things like that. And then, evidence of criminal dispositions, and then any prior immigration records. And again, they're going to find out, you're going to get get a request for evidence. If you don't, you need to be as forthcoming as possible. And, to avoid RFEs, just put it in there. If it happened, they're going to find out. So, you need to put it in there. Next slide. So you're also going to include a cover letter. It should be less than 5 pages. The cover letter should address the significant government interest served in granting DA, referencing the statement of interest and the labor agency's enforcement interest. I mean, you don't need to get into a whole deep dive into the underlying labor dispute, but citing the language from the guidance that came out in January. These labor agencies have also issued guidance, both DOL, NLRB, and more recently the EEOC. So grabbing language from that. At the end of this presentation, we are going to be sharing resources, and some of our colleagues across the country have created a manual practice advisory that has some really great templates of both cover letters and requests for statement of interest. So that's definitely a resource you all should be looking into and using. If, letters should demonstrate the worker falls within the scope of the SOI. So explaining what evidence you have in your application packet, and then giving a brief overview. You know, and in our case, we talked about the workers being present during the day of the nitrogen leak, or, you know, experiencing some of the other citations that were issued, you know, going over the retaliation that workers have experienced, going over, you know, the sexual harassment or discrimination workers have experienced, giving them a brief overview of the underlying labor issue, and then that the agency has provided a statement of support. Again, if you have a more complicated immigration history and or criminal history, going ahead and putting those positive equities in there, including worker participation, cooperation in the investigation, if that's happened. So, you know, going ahead and putting in the cover letter that your client filed a wage hour complaint and has been participating in interviews. Or if it's an instance where, you know, this client really wants to talk to the NLRB, but is very fearful because of threats of retaliation, this will ensure that this employer is held accountable. You know, I think something we talk about in this space is no one in this country wants employers to be getting away with and making a profit based on abusing workers and violating our country's labor laws. And so this is, you know, I think every person in this country is interested in ensuring that workplaces are ethical and are following our laws. And so this has a, you know, dual purpose of ensuring that the playing field is level, and for businesses, and that workers are able to come forward without fear. Your letters should go ahead and discuss worker immigration history and relevance for adjudication by either USIS or ICE. So if your client has an order of removal in absentia, or they have a case pending, they have a removal proceeding pending before the Executive Office of Immigration Review, EOR, those cases are going to be adjudicated by ICE. And so you can still send your application to the Centralized Processing Center in Montclair, but it's going to know that it's going to be forwarded to ICE, and you let your client know that as well. And so in that instance, you're just going to be explaining in your cover letter why this person is not an enforcement priority. And part of the reason that they're not a priority is because they've been a witness or are willing to be a witness in a labor investigation. I think we're touching on this later. I think Elizabeth may be touching on this, but if you're in, you know, pending immigration proceedings, we'll talk about some simultaneous work that experienced immigration attorneys can do with OPLA. And then if applicable, discuss factors for an EAD waiver or expedited criteria for an application. I will say overall, like the fact that there is this centralized processing center, they're already on an expedited review process. So the eligibility to be expedited beyond that is pretty high. So, I mean, we're happy to kind of talk to anyone offline about that, but we've found that it's really a challenge to say that a person is eligible for an expedited review because this is already kind of considered expedited. I think I got that right. Okay. So like I mentioned, the application packet require a written request signed by the non-citizen stating the basis for deferred action. So it doesn't have to be a declaration or, you know, a sworn declaration or affidavit under penalty of perjury. That's not required anymore. But you do need to have a statement saying, I've been working at this facility for X, or this work site for X number of time. I experienced XYZ. I witnessed XYZ. I'm willing and able to participate in the investigation, or I already have, and why. And I want to be able to hold my employer accountable, seek justice for myself and my coworkers without fear of, you know, being put into proceedings. Going ahead, like I mentioned before, if they have an immigration history, putting that history in the signed statement. I know the folks are doing this differently across the country. You can either have your client sign the cover letter or sign a short statement. You know, Elizabeth and I were talking about how it kind of seems odd to have a client who's most likely limited English proficient sign a cover letter. That's a work product created by an attorney. So I think in our practice, we just do a short statement that is translated, into the language that they can review and read and understand what they're signing. So I think people do it differently, but for us as attorneys, we feel more comfortable having like a statement that is in their language and in their terms, and that they can read and understand and sign. And, as mentioned, we recommend that this statement include details of all prior entries and other information, because folks have been receiving requests for evidence. So I have a prior order of removal, or I've been subject to 6 or 7 traffic stops, or whatever it may be. Okay, so this is kind of getting to the heart of that question we had earlier, to show, how do you show your workers within the scope of a labor agency SOI? How do you have to show that the worker worked for the identified employer during the specified period of time that is covered in the SOI or the specified, work site. So acceptable forms of proof are W-2s, pay stubs, time cards, contracts. In an FLS, a Fair Labor Standards Act case, oftentimes if the case has been, a back wage assessment has been issued, Wage and Hour will typically have a list of the workers that are owed back wages, so that can be attached. Yes, SOI is statement of interest. You can also, if you don't have any of these documents, a short declaration that is signed under penalty of perjury, declaring employment. And as I mentioned, we've been getting confirmation from the labor agency that the worker cooperated with the investigation. Just another quick practice pointer, talking about workers that are using other names at work. That was a huge issue for us with the Gainesville worker population. So in lieu of having them submit, W-2s or timesheets because they had their work names, we were doing these emails where we would email the OSHA investigator and say, just want to confirm that such and such worker was interviewed by your agency, and then they would email back and say, yes, I can confirm they were interviewed regarding this investigation, and attach that. When, Victoria and I were in the trenches together, kind of educating workers about what labor agency was going to be showing up and what this investigation was going to look like. We did advise them to use their real names, but we had folks that went ahead and spoke to OSHA without us knowing and did use their other names. And so we would just say worker, AKA other name. And that was sufficient as well. And again, they're going to have to admit to listing those other names in their application. So I don't think, and these applications that have looked like that have been approved, but just a practice pointer around the proof issue. So for workers with more complicated histories, any criminal dispositions, disclose and frame any criminal history, include any documentation related to immigration history. So notices to appear in immigration court, the actual orders of removal and absentia. And this is why doing FOIA is really important. And including those additional equities I talked about, letters of support, medical records indicating the need to stay in the US. That's a really important one. We had, these were a lot of the workers that we have been serving in Gainesville did suffer both mental and physical harm from the leak. And so in some instances, we did get medical records from their doctor showing that the nitrogen leaks, exacerbated their underlying medical conditions, that they have had to get therapy, that they have post-traumatic stress disorder. So those are things you can consider including as well. For all applicants, like I said, birth certificates, marriage, certificates of any US citizen family members, and then, like I mentioned, evidence of correspondence or cooperation with the labor agency.
So I know we're short on time, so I'm just going to go and briefly touch. I know I've talked about some of these issues and challenges before, particularly based on FOIA issues. So I'll just touch on a little bit on the others. I know we had a question earlier about workers with either pending removal order or pending removal proceedings or prior removal orders. And, something that we suggest, especially if you're an experienced immigration practitioner, other than letting your client know that these applications are ultimately going to get forwarded to ICE and be adjudicated by ICE, we also recommend that you consider submitting a PD request to local OPLA in conjunction or simultaneously as you're submitting the deferred action application for folks who have those ongoing removal proceedings. Some other issues we've seen, the transition to this new centralized processing center has not always been smooth. We've had applications that have been lost or delayed, requests for evidence that seem kind of arbitrary or don't make sense as they're training up, the USCIS agents. We're hoping that with time, we'll see these issues less and less, but definitely if you notice any patterns or repeated issues, something to raise with the agency directly, you can also feel free to forward those concerns with us. We are providing or trying to provide regular feedback to the agency about the process. And something else on the issue of renewals. So labor investigations, the reality is that they can take, and litigation associated with these investigations can potentially take years. So we know that DOL has and advocates have been working really hard to educate DHS on the fact that these investigations can take years. And so DHS up until now has been seemingly reluctant to be open to the possibility of folks renewing. And so really working on that education with DHS and saying, hey, actually we're going to need or DOL is going to need access to these workers, and they're going to need this protection for a longer period of time. And also you as an advocate can also play a role by proactively requesting these expansive statement of interest letters that contemplate, the need for renewals and the agency's interest in having these folks remain protected throughout the course of the investigation, which again, as I mentioned, can take potentially years. And yeah, I think that's it. Shelly, I know that we did get, I don't know if you want to hop on really quick. Oh, I see that you answered it already. Okay, so just briefly, again, because I know we're short on time, just wanted to leave y'all with some really good news, and some things in terms of what's next for immigrant workers who are brave enough to come forward and report these violations. So on March 30th, OSHA announced that they are going to become a U and T visa certifying agency. And so for those of you who are not immigration practitioners, U visas are special visas available to victims of certain crimes, and T visas are available to victims of trafficking. And both of these kinds of visas provide protection from deportation or removal, and also access to work permits and an eventual pathway to residency or green card and citizenship. So this is a much more permanent form of relief that is now available to some of these folks who may have been victims of these labor violations. So something to keep in mind also as you're screening folks is to screen them for eligibility for a U and T visa. And if they are indeed eligible, to consider making that request to OSHA. OSHA is not the only agency that will certify. OSHA joins Wage and Hour Division, which has been doing these certifications for a number of years now, and the NLRB and EEOC will also provide certification. So this is just really great news and the result of a lot of advocacy, and yeah, something to keep in mind as you're screening folks. So yeah, that's it on my end.
So we have some resources to share with you, and I think of the folks leading this training are going to be uploading this webinar online, but as well as our PowerPoint presentation. But there are hyperlinks on the PowerPoint presentation. So if you click on this hyperlink, social media infographics and KYR, we have a lot of infographics on our Instagram account and on Twitter and Facebook. And even TikTok about labor rights regardless of immigration status, kind of labor rights 101, which is really geared toward worker populations that's bilingual. But then also we have a whole series on deferred action specifically and on the OSHA UT visa announcement. And then below that, we have a labor-based deferred action practice manual that some of our colleagues across the country came together and worked on. It's very detailed and comprehensive, and is just a really great resource with some templates as well. At SUR, we are working on creating some template materials as well, template statement of interest requests, template cover letters, and we do have a deferred action toolkit as well. So, be on the lookout for that from us if you follow us on socials, and also just feel free to reach out to us. You can follow us on social media at arriba_surlegal_ATL or info@surlegal.org. Please do contact us for technical assistance on DA and EADs, labor-related UNT visas, and then labor complaints, especially with OSHA and wage and hour. We are a nonprofit organization, so please do consider supporting our work and making a donation. If you scan the QR code there, that'll send you to our donation page. Every penny helps, and so appreciate anything you're able to give to support us. And with that, I will turn it over to Victoria.
Well, thank you so much for this delightful presentation. I have learned so much. I've been out of the process for so long that this is really good information. I want to open the floor for maybe some last minute questions. If you prefer to put them in the chat, please go ahead. But before we take those additional questions, again, I wanted to thank our sponsors and our co-host, the Public Interest Law section, who graciously agreed to host this Zoom for all of you. And of course, as I said, my page, Florida Hispanic Bar Association, please consider joining, whether you are a Hispanic legal professional or you're just a supporter of diversity, please consider joining. It's a very cheap membership fee, but we can definitely use the help. So with that, let me check. I'm gonna stop sharing and let me see if there's any additional questions. Let's see. If not, I will definitely pass it to Alexis to give us the CLE code and some last remarks. But thank you all so much for joining us today. And I hope that you really got a lot of information. This will be shared via email. We'll share the PowerPoint. We will share all the resources that have been created by Surlegal. And if you have any questions, please hit them up. I'm sure they'll come back to you. Alexis?
All right, everybody. Yes, the CLE code, I just put it into the chat. It is 2303157N as in Nancy. And yes, this recording will be sent out to everybody. That email will come via Zoom, not my email address. So don't look for an email address, an email from me. Look for Zoom. I will put my email address into the chat just in case it doesn't, come forward, or it doesn't hit your inbox, or it goes to your trash or your spam. But it should come in that way. And again, I'd like to say thank you on behalf of the Public Interest Law section of the Florida Bar, also as a human being, for all of the amazing stuff that you do, that our advocates on this call do, and really just everyone that is in this sphere, not just our lawyers, but it takes a village to do this type of work. So thank you, everybody, for being here, and thank you to our speakers for teaching us. And with that, Victoria, is there anything else? I don't see any questions coming in to the chat. A very nice comment came in. It says, more important than the CLE, this gave me hope that there is something that I can do if a worker comes into my office and needs help.
Yeah, absolutely. I mean, this is work that is needed. And I mean, we have many legal aid organizations in the state that unfortunately are currently not providing this service, for example, because it's so new. But hopefully you can take that back to your organizations, or if you sit on the board of directors, you are a supporter of those groups. encourage them to make these applications. I mean, this is relatively an easy process, and they can actually see an outcome relatively soon compared to other legal proceedings that we all have to deal with. So I'm really hoping that Florida will step up and take these cases. I mean, we have people in packing houses all over the state. This could happen. I mean, what happened in Gainesville, Georgia happens constantly. We recently saw it in that Hershey, Pennsylvania plant. And during the pandemic, we saw so many essential workers who were dying in meatpacking plants because of negligence from the employers more than anything. So please consider raising the issue, uplifting these issues, and supporting immigrant workers in our state. Thank you.
All right, and we
right,
are
thank
receiving
you.
lots of praise into the chat. I think that's a fantastic note to end it on, but Elizabeth, Shelly, is there any last thing that you want to say?
Just thank you so much for giving us the space, and anyone, don't be shy, feel free to reach out to us. Thank you so much.
Awesome. And with that, I am going to stop the recording, and I thank you all and hope you have a fantastic, I think today's Friday, right? So fantastic Friday and the rest of your weekend. Thank you all.
Thank
Thank you.
so much.